Good evening, everybody, and thank you so much for being here. My name is Belinda Doolin. I'm the Executive Director of the Dispute Resolution Center, a community dispute resolution program that services Washtenaw and Livingston counties. We're so happy that you've joined us for yet another night around restorative justice in our education series. Please go to our website, thedisputeresolutioncenter.org, for more information about the center. Tonight, our education series will be adding to several conversations that we've had about restorative justice. Over the past year, we've had guests who have discussed restorative justice in juvenile court from Washington, D.C. We've had a guest to discuss restorative justice from defense counsel's perspective. We've also talked about mental health and mental illness and restorative justice. Tonight, we're going to talk about the Cook County program, Cook County, Illinois. We're happy to have Judge Spratt and Mr. Kenan-Devlin here to discuss the Cook County juvenile program, as well as the state legislation that has passed for the state of Illinois. So without further ado, I will turn this over to Kathy Gourlay to help us move further. Kathy.
Thank you, Belinda. I'm Kathy Gourlay, and I'm representing Friends of Restorative Justice of Washtenaw County. Friends of Restorative Justice and the Dispute Resolution Center are the primary sponsors of this series of events to educate people about restorative justice. Friends of Restorative Justice, or FORGE, as you see on my name there, which is how we often abbreviate it, started about 10 years ago with the name Healing Communities. It began as a collaboration of people from different faith communities around Washtenaw County, which is where Ann Arbor, Michigan is. And we were all working to repair the harm caused by crime and our criminal justice system. One of our members, Shalom Community Church, the local Mennonite congregation, taught the rest of us about restorative justice. Restorative justice has been practiced by Mennonites for 50 years, although restorative justice has been in use much longer by indigenous communities in North America and on other continents. Shalom Church members showed us a play called Tough Case, which demonstrates the use of restorative justice after a group of teenagers vandalize and steal things from an older woman's home. After a restorative justice conference, which was attended by the teenage boy, his mother, the older woman, and her son, a policeman was also there, and a restorative justice facilitator. After it, everyone understood each other better. They had discussed what had happened and what people were thinking and what the end result was. The woman, after the Restorative Justice Conference, was no longer afraid to live alone in her house. She realized that the person who had done such a terrible deed when she was away from home was just a kid and was not a danger to her. The boy and the woman came to an agreement. The boy returned items that had been stolen, and he repaired the damage he'd done by painting her house. Our current system isolates and punishes the person who offended. Restorative justice pays more attention to the person who was harmed and restoring relationships. It works to repair the harm and to strengthen the relationship between the person who caused harm, the person who was harmed, and also the community. Rather than pushing people out, restorative justice strengthens the ties between the person who offended and society. It also focuses on the needs of the person harmed. The play helped our group to realize that restorative justice provides a way to reduce our society's reliance on incarceration and to produce better outcomes after a crime. So we decided to change our name from Healing Communities to Friends of Restorative Justice, and we have continued to promote restorative justice ever since. This evening, we will be learning how Illinois has been encouraging restorative justice in its legal system and how they are using it in a Cook County court. We invited Washtenaw County Circuit Judge Patrick Conlin to moderate the panel discussion this evening. Judge Conlin was elected in 2014 and has served on the bench in Washtenaw County since. He is currently the Chief Judge Pro Tem of the trial court the presiding judge of the Family Division, and presiding judge for the Juvenile Division. Judge Conlin previously helped Friends of Restorative Justice by serving as the presentation of Tough Case, the play that demonstrates restorative justice. This was in 2016, and the play was performed at the Chelsea District Library. Before I turn it over to Judge Conlin, there are a few technical issues. First, as you notice, this meeting is being recorded. After the meeting, a link to the recording will be put on our website and also the Dispute Resolution Center's website to the recording. It will also be emailed to all of you who registered, so you will get the link in an email. As for the format this evening, Judge Conlin has some prepared questions that he will be asking the Illinois panelists. If you in the audience have questions, you may put them in the chat as they occur to you. These questions will be taken as time permits at the end. Lastly, if you have not already muted yourself, please do so. And now I'll turn it over to Washtenaw County Judge Conlin.
Thank you, Kathy. I am so happy to be here tonight, and this is such a noble effort, and I appreciate all of not only the presenters and looking forward to hearing about what's happening in Illinois, but also thank you to the participants, because your interest in this and your desire to see this grow is going to be what is going to be transformative to our justice system. I'm actually at a judges conference. Every judge in the state of Michigan is at a conference right now together. So I'm not going to tell you where we are in case the bombs go off to literally eradicate an entire branch of government, because we're all here. But I will say that there is a tremendous amount of attention being paid to restorative justice right now. The bench is absolutely committed to seeing, growth in this area. I'm here to tell you a little bit about what Washtenaw County is doing. I'm going to work my way up, because restorative justice has a particular, it's not entirely a term of art, but I think we all understand it a lot of the same way. And so I'm going to sort of end with our strongest program in what is, I think, traditionally defined as restorative justice. But I want to reassure you that not only do all the parts of Washtenaw County's courts, but I bet if each of you looked at every one of your courts, they all have programs that are designed to divert offenders or, defendants or people in trouble from the judicial system in a way that allows them to exit the system with some sort of wholeness or healing. And so I'll give you a simple example. In my court, we are seeking to get Supreme Court approval for what's called a foreclosure court. So I'm working with our county treasurer on a twice-a-year basis to try to keep people in their homes so they don't lose their homes to tax foreclosure. And so we set review hearings and we go forward that way to try to make sense of how they can enter a payment plan, get the taxes paid, and the people that need to keep their homes. That's a simple, small example. All of our courts have programs like the sobriety court or the felony drug court or the misdemeanor drug court as a way for people who are addicted and getting criminal charges to go through programs that look like probation, but when they graduate or they leave the program, they don't have that criminal record. And that's true. The family court is seeking to create some resiliency courts and forgiveness of child support. So I only just throw those sort of scattershot out to you to let you know that all of your local courts, wherever, if you're Washtenaw County or if you're Northern Michigan or if you're Illinois, I bet that most of your counties have programs to keep people out of the system where they can get through things like this that are not sort of your permanent record. Our two examples are our district court in Ann Arbor has created a program in conjunction with a prosecutor similar to what I just described, where pre-charges are diverted from prosecution. These are low-level misdemeanors, but the probation department, I'm reading this, so I'm not looking at you because I'm reading it from a judge, but our probation department takes the referral, works up a program for the individual. If the program is successfully completed, the case is diverted Programming can include substance abuse education or treatment, anger management, behavioral treatment, general community service. So that's a program at our misdemeanor level. But we also have what is kind of the longstanding partnership between the trial court and the dispute resolution center. So Belinda, if I don't say this correctly, I want you to chime in. But I have Judge Connors, who is our kind of leader in this. He gave me some written materials, but I just want to talk about our peacemaking program. And I'll read you 2 paragraphs from it, and then I'm going to read bios for our speakers so we can get to the real part of the program. But peacemaking in Washtenaw County is a traditional indigenous tribal approach to problem solving that focuses on healing and restoring relationships between parties in disagreement. It aims to improve the traditional courtroom experience in a process whereby everyone is part of a comprehensive solution. Parties come together in a circle with trained and experienced peacemakers. All members of the circle work together to reach a resolution through collective process in order to avoid adversarial litigation and further deterioration of the relationships between the parties. Because parties are able to feel heard and gain understanding of one another, relationships can begin to mend and heal. So that process creates opportunities, as described by both Kathy and Belinda in their introductions, just as to what we're talking about tonight. So we are eager to hear from, from Judge Spratt and Mr. Kenan-Devlin about the, I'm not going to sheepishly say more advanced situation and what's going on in Illinois, but part of this series is to educate all the interested people on this Zoom call about what other communities are doing. And so we're all keenly interested in this. I think we're all learning from each other, but I think the one thing that we can do I'm just speaking for Washtenaw County, is to really take note of what other communities are doing successfully to enhance what we're doing successfully. And so I'm hopeful that out of tonight will come kind of a lot of information for everybody, hope for everybody, and I'm grateful for all of your participation. So my next job is to introduce our speakers. So I'm going to introduce both Judge Patricia Spratt. So in case you were wondering, there's a lot of people on this call that are named Pat. So don't be confused. But Judge Patricia Spratt was sworn in as a Cook County Circuit Judge in September 2015, having been appointed to fill an unexpired term of a retiring judge. She has served continuously since then. Judge Spratt currently has 2 court assignments. On Thursday, she sits in the North Lawndale Restorative Justice Community Court, the first of its kind in Illinois. Here, the focus is on repairing the harm caused by the criminal conduct of a young person to a victim, the community, and most importantly, to the young person, to him or herself. Judge Spratt serves on 2 Illinois Supreme Court committees, the Committee on Professional Responsibility and the Judicial Performance Evaluation Committee. Judge Spratt's community activities include being a member of the board and a volunteer for Build Chicago Incorporated, a charitable organization whose mission is to engage community youth who are at risk of being harmed by or drawn into gang and criminal conduct. Judge Spratt volunteers in Build's public speaking program, which works with youth to aid them in developing confidence, poise, and presence, skills on which they can draw when being interviewed for college admission or job opportunities. So we're happy to have Judge Spratt speak to us in just a moment. Our other speaker from Illinois is Mr. Patrick Kenan-Devlin. Mr. Kenan-Devlin serves as the Executive Director of the James B. Moran Center for Youth Advocacy, an integrated legal, social work, and restorative justice organization. In addition to ensuring the effective implementation of the Moran Center's strategic vision, Mr. Kenan-Devlin continues to represent youth in juvenile delinquency proceedings and serves as a nationally certified trainer in youth defense practices. Mr. Kenan-Devlin has experience in the area of public policy in Illinois, as well as strong ties to the community. He previously worked as the health policy advocate for the Sargent Shriver National Center on Poverty Law and as legislative director of the Citizen Action/Illinois. Mr. Kenan-Devlin graduated cum laude from Northwestern University with a Bachelor of Arts and a Bachelor of Music, and then received his law degree from Loyola University Chicago School of Law. So we can't be more honored to welcome our colleagues and leaders from Illinois. I am going to present a few questions, and then I think you've gotten some instructions also from either Kathy Gourlay or Jermaine or Berlinda. If you want to put questions in the chat, that's the next step after we get through the questions that I'm going to ask them. So I'm going to turn it over to both of our speakers to just tell us a little bit about yourself and how you got started with restorative justice. And I'm going to let either Judge Spratt or Mr. Kenan-Devlin go. Thank you.
You're muted, Judge.
I am, and I intend to stay that way. You take the microphone first, Patrick. Go ahead.
I want you to go first.
Okay, no
All right,
fighting.
as the
with
judge,
children.
I'm just going to say sometimes the judges like other people to go first. I know
No,
everyone
they
wants to
don't.
laugh
I'm
at
the
our
son of a
jokes,
judge. Judges
and
never
let the
like to
judges
go
go
last.
first, but it's okay.
All right. If he's not going to pick it up, I will. All the summers in Chicago are nasty summers, and there's a lot of killing of young people who are not involved in gangs, but who are collateral damage. And you can pick any summer, but there was one about 10 years ago. Patrick, I think you'll remember it. It was the summer that Hydea Pendleton was shot. And it just brought me to tears. It brought me to tears because one thing I know is true. The young people, our children, are our most valuable, non-renewable resource. Each child has DNA that is unique to that person and has potential coming out of that DNA to serve humanity, to serve the community. And when we lose that child, that person, of course, has no opportunity to find their highest and best personal persona, and we don't either. So I got to thinking, all right, that's a truth that I know, and I know that these neighborhoods are getting into trouble every summer, but what can just one person do? I mean, after all, I am just one person. And I thought, okay, let's start looking to see what organizations there are that serve the youth in the underserved, overburdened neighborhoods. And as I started looking through Google, the website for Build Chicago showed up, and it is an impressive organization. I won't stress it too much. You can go online and look at it. It has a wonderful website. So I introduced myself to the director at the time of Build Chicago and asked, how can I help? And because I was at that time a practicing attorney, she told me, well, you know what, first off, come on the board. We need you on the board. And secondly, take over the public speaking program because we're losing the public speaking director. He won't be back next year. I said, okay, I'll do all of that. And I have done all of that since, was it 2013 that I went on. So it was my exposure to Build where I first saw peace circles. There are a lot of gang involved youth who come to Build after school to stay safe. And there are competing members of rival gangs there. And when they have a dispute, everything stops and they do a peace circle. And I observed this peace circle. It took perhaps 2 hours, no longer than 2 hours. But by the end of that circle, those two young men who were sworn enemies were in tears and hugging one another because they finally got to know the person that they thought they hated. And the presence of dignity, being able to do that in a circle process just blew me away. So when I saw that, I went to my chief judge and I said, do we do anything like this anywhere in any of our courts? And he said, well, funny you should ask. We're just now opening up the Restorative Justice Court in North Lawndale. And that was Judge Colleen Sheehan who started that. She was a judge in the juvenile division. And when she would have matters in court in Illinois, and it may be true in Michigan, juvenile matters are civil matters. They're not criminal matters, even though they might be detained. The youth may be detained in a jail-like condition, but so they're not public either. So that when they're in the courtroom, it's just the family and the youth and the police officer who got involved and arrested them. And she said so many times they're yelling across the courtroom at each other. So she asked if a particular police officer and a particular youth would be willing to sit in a circle. And they both said yes. And she said she had the same reaction I had to circles. The first time that a youth and a police officer and other people were in the circle, it has to be more than two people, certainly circle keepers. By the time that circle ended, the youth and the police officer were both in tears and were both hugging each other. So it's just a question of getting to human understanding. And she convinced Judge Evans to open up a restorative justice court in the North Lawndale community because it was ready for such a novel thing to open up there. There is a hub, a restorative justice hub in North Lawndale of 30 organizations that serve and provide the wraparound services to youth who came through the Lawndale Christian Legal Center, now to youth who come through the Restorative Justice Community Court. So that's how that got started and how I got involved in it. Patrick, your turn.
Thanks, Judge. So my backstory behind restorative justice is that I run an organization that for 40 years really worked within the muck of the criminal legal system. And we got to kids, young adults, emerging adults, when they were already in the system, meeting children, young adults in jail, and meeting them in a crisis, right? And as the Moran Center has grown and evolved as an organization, we have worked on the other side of the pipeline, helping people re-enter from the criminal legal system, and then also working to prevent people from entering into the criminal legal system altogether. But it still never felt enough. Still never felt good enough. And I say this to nonprofits all the time. I think every nonprofit needs to have a get out of business plan. Because if you're just constantly addressing the same problem over and over and over again, then you're not really serving your core mission. I mean, every nonprofit should envision a world where they no longer exist. And coming to that realization, I was really grateful at that time when we were wrestling with why does our programming still not feel enough? I met Father Dave Kelly, who is the executive director of an organization in Chicago called Precious Blood Ministry of Reconciliation. And I'm just going to warn you, I know you're talking to Patricia Spratt and Patrick Kenan-Devlin, and I just said Father Dave Kelly. There's going to be a lot of Catholic talk tonight. So I apologize to my non-Catholic brothers and sisters, but it's our origin story and we have to be true to it. But Father Kelly works in a neighborhood in the city of Chicago called Back of the Yards. And it is a neighborhood that has experienced incredible violence. You know, Judge Spratt mentioned in her opening remarks, the summers that we experience in Chicago are incredibly violent. And that is especially true in Back of the Yards. And Father Dave Kelly, as a Roman Catholic priest, believes deeply in the power of restorative justice. And I heard through the grapevine, because Chicago, although it's a big city, it really feels like a very small town, that he was doing something magical, that he was bringing victims and offenders together in circle and avoiding the criminal legal system altogether. Police not even being called in certain instances. What is this place? And so I went down and I got a tour of Precious Blood. And it really is an incredibly beautiful place, filled with incredibly beautiful people who believe in the power of human transformation and radical welcoming and radical forgiveness, and radical listening and radical healing. And I walked out of that place that day and I said, I have to learn more about restorative justice and restorative practices. And so that was day one. And from there, I have totally drunk the Kool-Aid, and I have gone to tons of restorative justice conferences and trainings, and I'm now a circle keeper. And the Moran Center now has a vision of building a restorative community where we are embedding restorative practices in our schools, in our neighborhoods, where we have a vision of being less reliant on what I often refer to as capital S systems that Judge Conlin and Judge Spratt and myself all operate in, that we are less reliant on those systems, and that we're more so reliant on informal systems, our neighborhoods, our priests, our rabbis, our neighbors, our community councils, our block clubs, that we're more reliant on those systems to resolve harm and to resolve conflict. And that with those informal systems, really bubble up to influence our formal systems, making them more restorative because we as a community are more restorative. So that's my restorative justice origin story, and I'm happy to share. So thanks, Judge, for asking.
I'm happy to ask. Thank you both for your sharing how you entered into this. I'm going to flip it back to Judge Spratt, only because Mr. Kenan-Devlin's questions that are prepared are super law school questions in terms of how the law evolved. So we'll hold off on that for just a moment. But this is a more comprehensive or kind of focused on the development of your court and how that program grew. So the question is, what are community courts, and how were you able to accomplish getting a court that focuses on restorative justice in your county? And I'm going to follow up with a couple of sub-questions after you kind of give me the big overview, okay?
Okay, well, so as I mentioned, it was Judge Colleen Sheehan who started all of this. And what she was able to do with the community, I mean, she dug right into North Lawndale, and they formed a standing committee that would investigate what it takes to open up a court. Of course, they needed funding, so they managed to, with the help of the Center for Court Innovation, they managed to get a grant from the Federal Department of Justice for $200,000 to open up the court. And with that money, they managed to put together all the moving pieces. They got the buy-in of the state's attorney's office and of the public defender's office and the various agencies, the social services agency that serves the court. Everybody bought in, and they got the court started in 2017. Now, that funding limited a lot of things, and I'm anticipating some of your questions, Judge Conlin. The grant required that they serve youth between the ages of 18 and 26. That's emerging adults. We've all heard about the fact that the frontal cortex is not yet fully developed for people in those ages, so they don't have executive decision-making skills. So we had to serve that age group. We also had to serve people who are charged with nonviolent crimes. They could have background, but it had to be nonviolent. So they didn't have to be first-time offenders, but again, no violence. And then they had to live, work, or worship in North Lawndale. That was the community to be served. And the members of the court, the stakeholders, had to be people in the community other than the court personnel. So that meant that the people who were caseworkers and the people who were circle keepers to the youth who come through the court had to be people who lived in that community. And then lastly, the youth had to admit responsibility for the conduct that they were charged with. So if those 4 conditions were met, we could continue with that grant. Now, that grant has long since been run dry. So we're no longer required to meet each of those conditions. And the conversation has already begun in North Lawndale to include violent crimes. We want to see if we can't evolve and be more inclusive of the people that we bring into the court. That's a conversation that has been started with our chief judge, and we have to take it to the members of the community, the members of that standing committee that formed the court, and see if we can be a little more progressive and include a little more people. So that's where we stand today. we've begun the Catholic Lawyers Guild again, with the aid of the Catholic Lawyers Guild again, we're starting to consider legislation that will alter the way we can have our young people who come through the court and graduate have the cases expunged. Now, when they graduate, there's no conviction, so they won't have a conviction on their record, but what they do have is an arrest on their record. And we would like to have, at graduation, we would like to have the order expunging that record entered at the same time. So that's going to require some more legislation, and we're going to tap into our legislative aids for that.
I'm going to jump in with a quick question, which you may not have an answer to, because I think you've kind of answered it already, but because it's kind of evolving right now. But the follow-up question was deciding on parameters of the cases, age, seriousness of the crime. Then you've defined kind of the original grant process and how that defined that. I guess my question is, if you were to look in your crystal ball right now, we're just asking you to forecast or prophesy, Judge Spratt, like, what do you think the community might be interested in? And do you think the community is open to, I don't know, expanding the age range up or down? Do you think the community might be interested in expanding the violent crimes? Just like taking a bit of the temperature that you might have observed.
Well, as to the age range, we can't go down. Our juvenile courts do not operate under a restorative basis yet. And of course, I'm a big proponent of it. And I want myself and my chief judge and all the other judges who are involved in restorative justice to take a road trip to New Zealand, because all their juvenile cases are held through restorative practices. And it would be an education. But it's not like going, to Michigan. Going to New Zealand is a little more involved. And expanding the cases that come before us, that will take community buy-in. And one of the hardest things about the COVID years is we've lost a lot of the community members who served the court, who served as mentors to the young people, who sat in circle with the young people. I've been asking the pastors in the community if I can speak to their churches to reinvigorate their involvement. And with the aid of the Leeds hub member of the Lawndale Christian Legal Center, knocking on the doors of the 30 not-for-profits organizations who served us to see if we can reinvigorate their interest too. And the thing that I bring to their attention, because it certainly hasn't been made widely known, that even including the COVID years, all the years that we've had youth coming through our court and have graduated, have come through successfully and have graduated, we follow them, and we know that we have a recidivist rate of 16%. Compare that to Cook County's system. I think the numbers are flipped. Their recidivist rate is close to 84%. So we're very proud. I would like it if we had no recidivists, but there it is. I'll take a 16% recidivist rate and use that to get more support for the court.
As you have worked in this program for these number of years, I know you didn't start it, but you have been doing it now. Can you comment a bit on any sort of pushback during that time? Like if communities are looking at this, what might a community expect in terms of pushback in these program opportunities?
And let me fill in the blank. After Judge Sheehan retired in 2019, my chief judge asked me if I would take over the North Lawndale Restorative Justice Court, and I said, boy, would I. Pushback comes in a different way. There are a group of people, many of them faith-based, who do not believe that there should be deputies in a restorative practice. And the truth of it is, if we have a court, and the court is housed in a local organization, we rent space from a local organization, there have to be deputies there, mostly because there's an elected official that presides over the court. And it wouldn't bother me if they didn't show up, because we've never had trouble with anybody at the court. But there are a group of people who don't think that courts should be involved in restorative practices. And the practices that Patrick described, the peacekeeping done before there's a charge, when there's a dispute that's criminal in conduct, but not anybody has been arrested. Let's get it resolved in a restorative practice so that there isn't going to be an arrest. And we support that. But the truth of the matter is, I firmly believe that the restorative justice court is very, very, very favorable, has a very favorable outcome for the young people who come through it. So when they tell me, but you have guns in the court because you have deputies, I say, yes, but what we have at the end of it is no conviction. There's no record of the conviction. People call this a second chance court. But if you understood the neighborhoods where these courts, we have 3 of them in Cook County now. I'm in North Lawndale. There's one in Avondale, which is on the north side, and there's one in Englewood, which is on the south side. We call these courts second chance courts, and I don't. It's a first chance court. The young people who come through our courts have not had an easy life, and they haven't had the opportunities that young people who don't look like them have. So I would advocate for the court, and if that means there has to be a deputy present and the deputy has to have a wand and check to see if you're carrying a gun, so be it. But that's the only pushback that I've gotten. There are a lot of judges in Cook County who do not understand what it is we do and how we do it. And because of that, the other 2 judges who are in the restorative justice courts in the other communities, we're putting together a CLE for judges. Like you, once a year, all the judges have to go to your conference, right? In Illinois, once a year, half of the judges go in February and the other half go in April. And we put on courses to familiarize our colleagues with things they may not be familiar with. So Judges Cooper and Santiago and I are going to put together a course for next spring to educate our fellow judges to what it is.
That's great. Thank you. All right, everybody, get a glass of water or something because we're about to go to law school, because now we're talking about some of the technicalities. So for Patrick, the law in Illinois has an issue for privilege. And so I'm going to let Mr. Kenan-Devlin explain that, but it is a concept of confidentiality and what can be shared and how that works in terms of information disclosure, and are you really violating your constitutional rights. And so restorative justice provides an opportunity for these pretrial, but also during criminal proceedings, how that might play out. So the question specifically is, what is the law in Illinois about establishing privilege for restorative justice processes, and how does this differ from confidentiality?
Right. Well, Judge, I am so glad you set me up the way you did.
I'm going to go get my own glass of water because I'm having a little PTSD about law school. Right?
Please do, Your Honor. Please do. And I promise I hope to not be as boring as your law professors. So this question really boils down to, what does the statute do? What does this new statute do? And I think it's really important at the outset to say that our community came to this proposal with the full understanding that this proposal really is only ever needed to be exercised when restorative justice fails. And I know I'm talking to a room of true believers, as am I. Restorative justice practices infrequently fail. I actually can't think of one restorative justice practice that I've ever been involved in that has failed. So I just want to provide that caveat at the top, that in this presentation that I've given now several times, I realize actually how negative I must sound about restorative justice, that it needs to be protected in this way. And yet, I think it is an important step that our state has taken in order to bring more people to restorative practices to make our community feel that they have greater liberties when they enter into a restorative practice, that they can be more truthful, they can be truly themselves when they enter into this practice. And that really is the underpinning of why we approached or why we came to this proposal. So the first thing, and probably the most important, is the preamble to the statute. It officially encourages restorative justice practices in the state of Illinois. I'm going to read this opening line just because I'm very proud of the language, because I wrote it. But the opening line goes something like this. The General Assembly encourages residents of the state to employ restorative justice practices, not only in justiciable matters, but in all aspects of life and law. That was a really important piece to the statute, in that tonight I know we've talked a lot about the criminal legal system, diversion programs, etc., and we probably will continue doing so. But it was really important to us as the drafters and the advocates for this bill that it not be limited to criminal programs, that it not be limited to the criminal court system or the criminal legal system, that we wanted to have the broadest protections possible for restorative practices in the nation. And so our bill protects all restorative practices on elementary school playgrounds, to divorce restorative practices, to restorative practices in the restorative justice community court, to restorative practices that take place on a street corner. All of those practices are now protected in the state of Illinois, and participants that enter into those practices are given a privilege between each other, and it's codified in our civil code now. Another few important things to tackle in talking about the statute. It really importantly defines key terms, and we define those terms using restorative language, which is also really revolutionary. It is challenging for lawyers not to sound like lawyers, but we tried our damnedest to really use this statute as a way to define terms using restorative language. So for example, when we define a facilitator, actually this is one exception, I shouldn't have set that up this way, but when we defined a facilitator in the statute, it simply says a facilitator means a person who is trained to facilitate a restorative justice practice. That's it. Judge Conlin at one point asked Judge Spratt, what pushback did you get in the development of the restorative justice community court? Well, let me tell you, we got a lot of pushback on this definition of a facilitator, because folks said, well, shouldn't there be some license for restorative justice practitioners, or an exam, or da-da-da-da-da. We got all of those comments. And we very resolutely said, we said two things. One, it is incredibly disrespectful and inappropriate to license restorative justice practitioners and circle keepers who have been doing this work for generations, if not millennia. So we do not need the state of Illinois to come in and professionalize or license restorative justice practitioners. That was the first. And the second is we threw back in legislators' faces the Uniformed Code of Mediation. So Illinois has the Mediation Act, which almost all 50 states have adopted the Uniform Code. And in that, it says a mediator means a person who is trained to mediate. That is literally the definition from the code. And so we just borrowed that language, and I would encourage others to look at their Mediation Act in their states, in the state of Michigan, because I am certain that it is similar. It is similarly defined. And so if we allow mediation to have such a definition of a mediator, it would be appropriate to mirror that in the restorative justice privilege proposal. It also, as I mentioned, importantly defines restorative justice. And this is where I really intended to make my comments about borrowing restorative justice language in a state statute. So I'm just going to read for you all the provision that defines a restorative justice practice. It goes something like this. A restorative justice practice or practice means a gathering, such as a conference or circle, in which parties who have caused harm or have been harmed and community stakeholders collectively gather to identify and repair harm to the extent possible, address trauma, reduce the likelihood of further harm, and strengthen community ties by focusing on the needs and obligations of all parties involved through a participatory process. That's the language that we came up with, and I hope that you hear in that definition restorative language. So we tried to not sound too lawyerly because it was really important for us to honor our ancestors and to honor how they approached restorative practices and how they would define a restorative justice practice. And also, I hope you hear that in that definition, we don't limit it to a program or to a special court program or to a diversionary program or to probation, as you'll find in many state statutes across the United States. It is a broad definition, and it was intended to be broad. In our proposal, we were very surgical in how we approached protecting restorative practices. And at its core, what this proposal does is it ensures that any statement made during a restorative justice practice is privileged, meaning that it is inadmissible in any court or administrative proceeding. Additionally, since restorative justice practices often involve pre- and post-conference and meetings, as many of you know, anything said in preparation for or as a follow-up to a practice is also privileged. So that is the key protection that's provided by this public act. It's Public Act 100-102 for any of you legal beagles out there who want to find it in Illinois state statute.
All right, can you
We're
repeat
hoping you're going to
the second
provide
one?
it, actually.
I'd be happy to.
Can you repeat
I'll put it in the
second
chat.
one?
Say again?
Can you repeat the second part of that?
Sure, it's Public Act 100-102. And I'll put the link to the statute in the chat, and then the state citation for those who are real legal beagles. It's 735 ILCS 5/804.5. And again, don't feel pressure to write that down. I will share that out with everybody in the chat once I land this plane. So for those who are scratching their head, because I'm not assuming that I'm just talking to a room full of lawyers, it's also important to note that parties who have a privilege also are often afforded the right to waive the privilege. And any participant in a restorative justice practice can waive the privilege during a judicial or administrative proceeding or in writing by the party or parties that are protected by the privilege. However, you can only waive the privilege as it pertains to what you said or what you did or your actions. It does not breach the privilege further than that. So that's a really important note. The judge asked me, confidentiality. What's the difference between providing a confidentiality protection versus a privilege protection? And I would just say up front, our proposal does not provide a right of confidentiality for restorative justice practices. And for those in this space who are restorative justice practitioners, know that confidentiality is generally a core tenet of any restorative practice. Usually that's one of the values and principles that we agree upon when we enter into Circle. Confidentiality, though, from a legal perspective, is a fairly hard thing to enforce. Whereas privilege, once codified in our Code of Civil Procedure, really is a clear delineation to the court as to what statements are inadmissible and what statements are admissible. And so that's why we as lawyers gravitated towards privilege as opposed to confidentiality. Because confidentiality, and I'm going to sound like a real law professor here for a moment, but confidentiality is a principle of legal ethics that governs when communications may be disclosed and when, more commonly, they should remain confidential, whereas privilege is really more absolute, and it protects against compelled disclosure in a deposition or a trial proceeding. So we actually felt that privilege was a far more sweeping protection that could be afforded to participants of a practice. Now, I will say, and I didn't love this part of the drafting, that we did include some confidentiality language in our proposal. And we did that because we really wanted legislators to recognize that we understood the limitations of this protection. And we wanted to give them language that they were familiar with that would kind of lower blood pressure. So in the proposal, we do say that the privilege does not apply when disclosure is necessary to prevent death, great bodily harm, or the commission of a crime. When it's necessary to comply with another law, or Judge Conlin probably would appreciate this, when a court needs a report on how a restorative justice practice went. Not the fine details, but at least did it take place? Did it achieve its goals? What agreements were reached during that privileged restorative justice practice? So that's also in there as well. So I'm going to land the plane there and come up for air, and hopefully none of you are asleep at this point.
I'm going to give you a moment to take a breath, although I'm not turning from you yet. I'll just point out that that's a similar thing in Michigan when parties enter into a mediation procedure, especially in family law. You know, what's reported to the court is simply that the mediation occurred, whether it was successful in settling the case or not. So the details were still left out because they are privileged. And so, you know, that's consistent. And so I appreciate that. I'm super appreciative of your description, though, as how you described kind of the concern about licensure of participants or leaders versus the millennial old traditions that have been incorporated. And then, you know, again, but addressing the modernization because of the issue of disclosure. I know confidentiality and privilege are similar in concept, but privilege is a more potent legal term. And so, you know, thank you for that illustration. I'm going to give you both of the follow-up questions to this because you've actually kind of answered a little bit of this in your response. So I'm just going to let you describe a little bit further. But the two follow-up questions were, who were the main stakeholders involved in the initiation of the legislation? And then the second one is, how long did the process take to develop and pass that legislation and the keys to its successful passage? I mean, I know you touched a little bit about pain tolerance on that, but anything else you'd like to add on that, that would be great from history.
Sure. I think it's really important to note how we got started, because how the state of Illinois ultimately promulgated this proposal, is not necessarily how other states have to approach it. So, and I know that for certain because of our failed attempts that led us ultimately to the passage of Public Act 100-102. So we started in the Illinois Supreme Court. We proposed a rule, an amendment to the Illinois Rules of Evidence that would codify within the Illinois rules a privilege for restorative justice practitioners. And we proposed it to the Illinois Supreme Court Rules Committee, and we had a hearing, and they said no. They felt that it was an overreach for the court to codify such a privilege and that we needed to go to the legislature. But that doesn't mean that the Michigan Supreme Court would have a similar conclusion. I believe that actually our courts could, if they so chose, approach this within their rules of evidence. So I would just say, learn from our failings, but don't be scared by our failings, because we have different high courts in each state. So that's one key piece of background, Your Honor. The second key piece of background is the Catholic Lawyers Guild. And I know Judge Spratt already mentioned the Catholic Lawyers Guild at least twice. But this is a group of lawyers who are dedicated to being champions for justice in our state, and that means championing restorative practices and restorative justice. And they brought together an incredibly broad coalition that was also multicultural and multi-faith and interdenominational, that drafted the proposal, then lobbied on behalf of the proposal, and brought some really key players to the table. I am Roman Catholic, and so I feel very free to criticize my church. We are not often the most enlightened of denominations. And yet that was actually to a great advantage for us in our advocacy, because our Archbishop, Cardinal Blase-Cupich, was an incredible champion for restorative practices. And yes, we are a very Catholic city and a very Catholic state, and having his support from the outset for this proposal was really incredibly important, and ultimately led to bipartisan support in the legislature. So it passed out of both bodies with bipartisan support because we had such a broad coalition that had a unique interdenominational coalition supporting it. And so I have advised folks across the country to be really creative. And I think that often we in this country say, oh, well, that guy, I'm never going to agree with him on anything. And so I'm never going to talk to him about nothing. Well, restorative justice actually has the ability to bring everybody together. And it is a core value of restorative practices. So I would really encourage my brothers and sisters in the great state of Michigan to think broadly when you are building your coalitions about who to pull in, who to talk to, because you may be surprised at the breadth and depth of the coalition that you build. And I think that's why we were ultimately successful. It did take us, Your Honor, 3 legislative sessions to get it through, but so it did require persistence and having that really broad, deep, committed coalition, I think, was incredibly important to its ultimate success in the chamber. Judge Spratt, I didn't mean to stomp on you.
You didn't. You didn't stomp on me.
Oh, good.
Judge Spratt, do you have anything further to comment? I think I've got one more general question for both of you, and then I know there are some questions in the chat. So is there anything you want to comment on what Mr. Kenan-Devlin just shared, or do you want me to offer my last question?
Yeah, he's given you a very, I hesitate to say, but we'll say it anyway, sterile legal analysis of the act. I want to tell you what the human effect of it is, how it has helped our court. When the young people come to us for the first time, and mind you, they're transferred from either the branch court or the 26th California criminal court before even the preliminary hearing. So they're identified by a state's attorney who knows the parameters and sees, okay, this person meets all the parameters to be sent to North Lawndale, so we're going to continue their case in North Lawndale. So they show up at my court not knowing what they've been sent over for. And they sit there with attitude. They're so bound up in layers and layers and layers of emotional body armor because nobody has ever wanted to hear what their story is. Nobody has ever wanted to recognize their dignity as a human being. So I have to make sure they understand that in the circle process, and there's 3 places where that under the legislation that occurs. First, our social services participant who does an ORAS assessment of, that's the Ohio Risk Assessment Survey of their needs and their potential. They have to be open when they have this discussion with that person from social services. So that's one of the places where the privilege is available. Secondly, it's available when the circle keepers are doing the pre-circle, which is getting some private information, personal information about the young person before they set up the circles. And then finally, in the circles. So there's three places where whatever that young person has to say, they can feel confident and safe that what they're going to say isn't going to come back and bite them in the rear end. And sometimes they have to talk about prior criminal conduct that they haven't been charged with. And they know that if they raise, or at least before this privilege, if they raise it, they were at risk. If the state's attorney heard about that, they would be hauled off to another court. So in practice now, when I tell them the first time they're in the court that they have a privilege, and that anything they say in the circle process at those three different stages cannot be used against them, they relax. I just see a little bit of a relaxation come over them. And as they come back to court, and they come back periodically just to let me know what's going on, a status report, as I see them work through this circle process, I see that emotional body armor melt away. And when they sit down in front of me for the first time and they actually smile when I say good morning, I know they've been completely removed from their body armor and they've been open in the circle process. And I ask them, don't tell me anything that was said, but tell me your view of the circle process. And they tell me, it's really great. I'm making friends. People are listening to me, things that they've never had in their life. So that's the human effect of this legislation.
And Your Honor, if I just may add one other point that I failed to say at the top, which is, I'm trying to choose my words carefully. I am a youth defender. I love being a youth defender. I love representing children. And the defense bar was a great hindrance to restorative justice practices in the state of Illinois. And I get it. And I get it. And it is because the defense bar was terrified as to what Judge Spratt just referenced, that they would advise their clients to be part of a restorative practice and that they would admit to some other offense and that could be then later used against them. You know, a statement against self-interest is one of the hearsay exceptions. And so that's one of the reasons I think we as a bar were pulled towards codifying this privilege protection within our state statute, because we thought we could also bring the defense bar's blood pressure down, and that we could have them see the power of restorative practices without jeopardizing the rights and liberties of their clients. So I would also just add that into the conversation, that the defense bar can also kind of throw some wrenches in restorative practices, and that's why this protection is really key to getting them involved and excited about restorative practices.
Now that's really interesting. The pushback that I was involved in was the state's attorneys were all against it. So I was tasked to talk to the state's attorneys in Cook County and then countywide or statewide, because it's a statewide law, you know. And as it happened, during the 3 sessions that it took the legislation to get passed, the state's attorneys stayed quiet.
Yes, they were neutral. They didn't support it, but they were neutral.
Right. Yeah, I had heard that they were going to write their own version of it, and that didn't happen. So that's my powers of persuasion. I'm taking
nicely done. Nicely done, Your Honor. I'm going to just share with the Michigan residents that every judge in the state heard this today. Judge Spratt just talked about the human side of this. I'm in a statewide conference for all the judges in the state. So our keynote speaker talked about kind of the evolution of how criminal proceedings are perceived. I'm not saying this very artfully, but he was talking about juvenile offenders. And the quote that I wrote down for the day, so those of you that live in Michigan, we all heard this, is that these kids, whatever age they could be adults too, are much more than their worst choice on their worst day. And so they cannot be defined by the action that they took, as horrible as it might have been, that they are human and that they need connection and that they need this connectivity to not only heal themselves, but heal the rest of us. So that's something that every judge in the state of Michigan heard today. So
That's something that I tell them when they come to court. I tell them, because they don't know what they're getting into, the difference between the criminal court and my court. I tell them in the criminal court, all they're interested in is a moment in time in your life. The moment you came to the attention of the authorities and you were arrested. That's it. And if you go to court and your lawyer will tell you, we're going to make the state prove its case, and you're not going to testify. And if you take that tact, you don't get a chance to talk to the court. And if you're convicted, at sentencing, the judge finally asks you, is there something you want us to know? I tell them, when you come to my court in circle process, we want to know everything. We want to know what brought you to that moment, what your life has been like, how you made the choices you made, and based on what conditions have you been living under. We want to know who you are. So we are encouraging you to be open and honest with your circle keepers, and you know you have this privilege to do it.
So the last question that I'm going to pose to both of you, and I think, again, you both have touched on this in your earlier responses. So, for example, Judge Spratt, you talked about wanting to bring this to the juvenile court or the other courts, but the question is, what are your goals to further the effort, either through the judiciary or the legislature? So if you have anything more to add, Judge Spratt, if you care to, or Mr. Patrick, Mr. Patrick, I'm Patrick too, Mr. Kenan-Devlin, just feel free to supplement that. And otherwise, I think then I'm going to stop talking and let our other moderators give you some of the questions from the participants.
Well, what I would like to do immediately is get more restorative justice courts opened up, at least in the city of Chicago. We have 77 neighborhoods, and we only have 3 neighborhoods where we have these courts. If we could open them up all of the neighborhoods in Chicago, and then we could start infiltrating the rest of the state of Illinois with this idea of a different type of justice, and we could be a model. Michigan, I'm so impressed with everything you've done ahead of what we've done. You're a model for us, but if we could have more of these courts, then we could talk about expanding the purview of the court. Okay, let's work with criminal or violent offenses. Let's work with any number of things that people have reasons to come to court with. I certainly encourage it in civil court. We don't have that yet. I think we need to get that going. Patrick, let's work on that. Let's take it to divorce court. Let's take it to small claims. Let's take mortgage foreclosure. You talked about that, Judge Conlin. That's my other assignment.
Your other job.
4 days a week I sit in mortgage foreclosure, and I see the terrible things that are happening there. I would like to start a circle process. Of course, I don't believe that lenders would sit in circle with mortgagors, but there has to be a better way.
Maybe.
Yeah, there has to be a better way.
You never know. You never know. I would just say that, what I'd like to end with, Judge, is just to relay the Moran Center's vision for our community. So the Moran Center is based in the city of Evanston, which is in Cook County, but it is not the city of Chicago. And what I love about working in my little city is that it's a little city, 70,000, 80,000 people. Where, right before this started, one of my kids got arrested. My social worker was up the street, so she ran down the block, saw the kid was getting arrested. I could call the chief of police on my cell phone and say, hey, I'm about to go give a talk on restorative justice in the state of Michigan. I'm asserting my client's Fifth and Sixth Amendment rights. I mean, I really am a country bumpkin lawyer. And I think there's value in being a country bumpkin lawyer, because what we're able to do in our little city would take years, if not decades, in the city of Chicago, just because it is so massive. For example, in our city, we no longer arrest children for misdemeanors. They are all met by a restorative and supportive services program. We are in the process of training tons of people to be circle keepers and creating informal systems within our community where hopefully we are resolving conflicts without the court's intervention, without the police's intervention. We're trying to teach everybody from little kindergartners, my kids in kindergarten right now, restorative practices in their classrooms, and having high schoolers be the ones that are in the kindergarten classrooms teaching restorative practices, because we want everybody to build the muscle of being in dialogue with each other when it's not a conflict. So when a conflict ultimately does arise, they know how to mediate, they know how to have a conversation, they know how to dialogue. So my vision really for the future, Judge, is not the judiciary or the legislature. It's looking more inward to community and hopefully building a model that can then be replicated in other communities. That's where I'm laser focused right now.
Well, thank you. I'm going to turn the rest of this over to our more astute and better moderators. I think Carolyn or Kathy or Belinda or Jermaine, I think, are collecting questions from the group. So I'm going to let them speak and ask those questions. And I thank you. I'm not signing off, but I just want to thank everyone for your attention and your thoughtfulness and your great responses. And so it's been a real privilege, not to use that word, it's been a pleasure for me to be part of this tonight. So thank you. And I'm going to mute myself.
Yeah, thank you very, very much. You've been a great part of the presentation. What we're going to do right now is Jermaine is going to ask there's questions in the question and answer, and then there's a few in the chat. So please put some more questions if you have some. We'll try to get as many as we can until 25 after, and then we'll have a closing with Kathy Gourlay. So Jermaine, you want to start with the one in the question and answer?
Yes, yeah. Thank you, Carolyn. Also, I wanted to thank, of course, Judge Conlin for moderating this evening, and our guest, Judge Pat Spratt, as well as Patrick Kenan-Devlin, and of course, Forge and the DRC for hosting tonight. So the first Q&A that came through is, have you used restorative justice court practices for R&Os, i.e. resisting and obstruction charges, ? So that's the first part of the question. And then when you see this, how are officers reacting to it? So I don't know if you need more clarification from the audience member, if she's still here, but it's sort of a two-part question.
Well, in North Lawndale, we haven't seen an offense of that nature involved in a case being transferred over from the criminal court. I don't know if they have seen it in Avondale or if they've seen it in Englewood, but I would almost think that that would be considered a violent offense, and that would not make it its way over to us.
So, Judge, I have a story that I think you'll really enjoy. So we had a kid who was charged with aggravated battery, and it was an aggravated battery because the battery was perpetrated against a peace officer. And kid was arrested, charged, brought to court, and we berated, and I don't think there's a better word for it, the poor state's attorney in that courtroom, and said, you know, this would be a great case for restorative justice. This would be a great case for restorative justice. And we used the restorative justice community court as the rationale. We said, look, you know, there are other cases that are being diverted out of the criminal legal system in Cook County. Look at the restorative justice community courts in Avondale and Englewood and North Lawndale. And we ultimately wore her down. And then we went to the police officer and talked to the police officer, provided the kid's backstory and life story to the officer. And the officer and the state ultimately agreed to a restorative practice. And the practice is going on right now, and I'm really confident that the case will ultimately be dismissed. So I do think there are officers that are out there that are open to hearing people's stories and are willing to be part of a restorative justice practice. I gave a talk actually earlier today on restorative justice, and I said, and I'll say it again, that doggedness is not mutually exclusive from being a restorative person. I think restorative advocates have to be dogged because what we're doing is trying to change systems and hearts and minds, and requires doggedness. And so, Judge, I actually use your courtroom as a reason why my kids should get restored. So, even though my kid wouldn't qualify to get in your courtroom, but nevertheless, I used it.
I know I promised to be quiet, but let me just offer for the participants, though, R&O is resisting and obstructing. In Michigan, it also includes assaulting. So Judge Spratt is correct. In the felony criminal, the adult criminal division, those are felony crimes. They are potentially aggressive or assaultive in nature. But the other side of that, though, where you are sort of imagining this application is exactly right. Because the other way that people get charged with R&O is fleeing. There's no assaultive behavior there. Someone is running from the police. They get pulled over and they take off. And so the idea of applying these types of philosophies where there isn't an injury, where there isn't, that kind of thing, I think that these are the types of discussions that are important for all of us to have because they apply to kids and adults as well. So anyway, my 2 bits. I promise I'm muting my.
I will tell you that I have a state's attorney in the room who is not your typical state's attorney. He grew up in Englewood, which is one of the most violent neighborhoods. He managed to stay out of gangs, got himself through college and through law school with the intention of becoming an assistant state's attorney and working in a restorative justice courtroom. And this young man has been the subject of much police harassment because he has dreadlocks, he has nose piercing, he has tattoos, but he shows up every week in a suit and a tie. We call him our unicorn because he is the biggest advocate for some of our marginal participants who are on the cusp of being sent back to 26th Street. So I think we need to produce more young men like him who will be on this side of restorative justice.
Okay, Jermaine, I'm going to take one from the chat. So one question is, or I'd say, could privilege apply to circles held with citizens returning to community from prison and on parole?
Yes. At least under our proposal, the simple answer, yes.
Okay. And then one of the other questions here for Judge Spratt, what does the person who caused the harm need to do to get a circle going?
Well, this is how it works in our court. They come to us, we get them, first and foremost, we get them through the social services process, have that ORS assessment done. Then we give them a case manager, and then we give them 2 circle keepers. And the circle keepers then set up the circle. They do a pre-circle and they set up the circles. The circles occur outside of court. We don't do them in court. And as much as I would like to sit in on a circle and see how it goes, I know I would have a chilling effect in any one of those circles. So they happen on everybody else's time. And it takes however long it takes, because the point of the circle ultimately is to come to an agreement with the community of what it's going to take to repair the harm. They come up with a repair of harm agreement. And there's an infinite variety of tasks and goals that can go into that repair of harm agreement. It can be if they don't have a driver's license, but they need to get a job, so they need to have a car, so we help them get a driver's license. If their driver's license has been suspended, we have the resources to help them work through the court system and get their driver's license unsuspended or get it reinstated. If they want to be someday a long haul truck driver, they need a CDL license, a commercial driver's license. We get them the resources to do that. Or if there's been a victim and the victim has been harmed, then they'll agree to make restitution. Or if it's something as simple as painting the house, because they put gang symbols on the house. But these are all things that the circle keepers, the case managers, the participant, him or herself, and if there's a victim, they all agree to it. Nobody is forced to do something they do not want to do. And if they find that they can't do something, we like to have our participants go through a program that we call Stick Talk. It's all about safe gun use. And it takes place in a distinct neighborhood that some of the participants can't cross the boundaries to get to because of gang involvement. Well, if they can't do Stick Talk, they go back into circle and they replace that goal with something else. But nothing is forced. It's all by agreement. And once they have a repair of harm agreement, then they come back into court periodically to give me a status on where they are in completing all those goals or tasks to complete the repair of harm agreement. And when they have completed the repair of harm agreement, the state's attorney moves to dismiss, and I loudly say granted. And then there's a big round of applause, and we tell them how proud we are of what they've done, and they should be proud of themselves. They should be hearing a stadium the size of the Super Bowl of people going, yay, because of what they've achieved. That's how it works in our court. And then we ask them to come back some months later because we'll have a graduation ceremony and celebrate all the people who have graduated in that year. We do that in November.
Wow, this is an inspiration. I'm sorry I'm pushing a little because I'm trying to get a few more questions in before we have to close. I assume, Judge Spratt, you'd be willing to talk to someone's asking if you'd be willing to talk to a pastor in Forest Park, Illinois about restorative justice.
Give me a microphone.
Okay, so this person will make sure that everybody has your information and they can follow up and make that. Jermaine, you have another question, and then we might have to go to close. You want to try one more question?
Yes. But first, I just do want to say that I want to elevate Judge Patrick Conlin in Washtenaw County, who is a huge proponent of restorative justice practices. By the way, he actually sends a lot of cases to the ERC, especially when it comes to family situations that I personally handle through either peacemaking, restorative justice, mediation. So I just want to say thank you, Judge Conlin, for what you're doing for our community, and just wanted to elevate that for folks in the audience. So thank you. So the next question is, can you comment on the speed and timeliness of RJ procedures to come to a conclusion? Is that an issue for processing cases? So my guess is this is kind of a logistics question.
Well, I tell the participants when they come through, they're in charge of how long it takes them to get through the process. They're in charge of how many circles they need to come to a repair of harm agreement, and they're in charge, once they have that agreement, of how long it takes to complete all those goals. We have had some young people, certainly during the COVID era, we had some young people who took a long time they agreed to do community engagement, and they found it was very hard to do because everybody was quarantined. So we let them take however much time it took them to get that done, because they did not want to go back into circle and change that task. They did want it to meet people in their community and attend turkey giveaways and help give away or neighborhood cleanups and meet their neighbors. That's the whole part of it. So we like them to complete the whole process in a year, but there have been several young people who've taken, one who took up to 4 years, but again, that was COVID that interfered with his ability to complete everything. We'll work with them. We'll only send them back to the criminal courts if they are recalcitrant and if they don't engage and they don't let the process run the course that we know the process can run. And that only in the years that the court has been in, let's see, it's been since 2017. There've been 400, how many, Patrick?
I thought you were looking for how many years, Judge. Sorry.
Yeah.
I don't know how many cases.
Since 2017, and
Right,
we've had 400 some people come through the court. Only 25 have been sent back to criminal court. And believe me, especially with the state's attorney we have now, it's tearful. We hate doing it because we know if they would just let the process occur the way it should. They've come out at the other end.
We have a few more questions. We could take them down, we'll copy them and send them to you and Patrick, and then we could send them out. We're going to send the recording to all the people that are here. Would you be willing to answer one or two more questions? Or?
Absolutely.
Okay.
Yeah.
Okay, one more here is about circle keepers. So how do we, the training of circle keepers, how much training do they get? And are they fully volunteers, or I guess the question
I
is-
actually answered that question in the
Oh,
chat,
did you?
Carolyn, for the person,
Okay,
yes.
okay, sorry, okay. Okay, let's see. Yeah, okay, I see that. Jermaine, do you have any others that,
Yes, actually,
one more.
there
Yeah,
is
let's do
one.
more. Yeah.
Yeah, so there's one more. Have you seen any restorative justice cases in which there is no quote unquote victim in the sense of quote a person harmed?
We have a lot of those. The cases that we're getting now, in the beginning, were all drug cases: drug possession, drug use, drug manufacture. So we don't have victims. So we use a surrogate victim to sit in circles so that all the parties are represented. The party who is harmed directly, we have a surrogate victim. We have somebody representing the community to represent the community's harm. And then, of course, there's the young person who's representing their own harm. Now, though, we have a new court. We have the seed court where the drug cases are going. So now what we're getting are gun possession. That's a specific crime called unlawful use of a weapon. And it's not used. They're just in possession of a gun. They're not waving it. They haven't pointed it at anybody. They just have a gun in their possession. Again, there's no direct victim there. We did have one retail theft case, and the manager of the store, it was one of the big box stores, agreed to sit in the circle and participate. And when that case was resolved, that manager said, "Can I come back and be a volunteer?" And we said, "Absolutely."
That's great.
Yeah.
We actually facilitated a restorative practice not too long ago, where a client of mine perpetrated a really actually significant financial fraud on a financial institution, and we got the CEO to sit in a circle with this young person, and the kid completed 200 hours of community service. That's what the CEO wanted, to repair harm, and some restitution. But ultimately, the kid was never even arrested for the offense. And
Wow.
in the state of Illinois, for the amount, he could have gone to jail for up to 30 years. So it was an incredible outcome. So again, doggedness, it never hurts to ask if someone would be willing to sit in circle. And as Judge Spratt mentioned, obviously we have to be victim-centered, that you cannot force anyone to be a participant. But I think the invitation should always be made. I also just wanted to circle back to a question. Belinda, I know you answered it, but I felt that maybe it was also pointed at us too about our circle keepers at the Moran Center. So we have two full-time staff members who are circle keepers, but then we also have community members that we train in restorative practices. And the only reason I really just wanted to focus on that for a moment is because I think oftentimes in restorative practices, we expect people to volunteer. And it's great, right? I love volunteering. And particularly if you're asking people of color, people who have been oppressed by these systems, to volunteer and to not compensate them for their time, it is, I think, another form of oppression. And so it's really important that when we ask folks to take a leadership role in restorative practices, that their time is respected and that they're compensated for their time, because it is of incredible value to our community to have them. And so it does require, folks like me who have to raise money for a living as an executive director of a nonprofit to work a little bit harder. But I think it produces greater equity within the system, that everyone is compensated for their time. So I love volunteers, and I think we as the sector have to be more resolute on compensating people for their time and
And
valuing
I
it.
absolutely agree with you, and that's a large conversation with our state court administrative office as they consider funding for us, and we must record volunteer hours and that kind of thing. But I love hearing that because that gives us more information to share with them.
So what we've done at the North Lawndale Court is we had for 2 years 2 pairs of circle keepers who weren't paid for what they were doing. They were volunteers, and they're still with us. But I thought that was wrong, so I managed to lobby my chief judge, who lobbied the county. We've got them now as county employees. They're paid for their time. Circle keep case managers are paid by their agencies, where certain agencies supply us with case managers, and circle keepers are paid by the court.
And Judge Spratt is dogged.
Well, Patrick, I'm Catholic and I'm Irish, so there you go.
Dogged.
Okay. I see that Judge Conlin had to leave us. There are a few more questions, but one question I'll just push forward. Someone's asking about the gang violence. Since many of us outside of Chicago hear a lot on the news about gang violence, the question is related to whether restorative justice has been used, maybe not necessarily in the courts, but if that's okay. But is there a process that's trying to approach that problem in Chicago?
There are some agencies, private, nonprofit agencies, that is the organization on whose board I sit and where I volunteer build. They'll do circles with people who have been engaged in violent crime or violent acts, I should say. This is pre-arrest, but not through the courts. The court has not yet been enlightened enough to allow restorative programs for violent offenses. I want to get that changed.
Okay, I think we'll keep the chat, and so if there are a few more questions that we haven't covered, we can get them to you and see what your response might be to that. So for closing, Kathy Gourlay is going to give a close, and again, we're all so grateful, and she's going to tell you how grateful we are.
I can't do it justice, but it's I learned a lot. I'm excited after hearing what you've done, and it's just amazing how everyone seems to get passionate about restorative justice once they recognize its power. It's just such an entirely different way of looking at crime and conflict, and it's just amazing. It makes me feel like the world is a better place because we can do this. So thank you for sharing your passion with us tonight. I also need to thank 3 of our co-sponsoring organizations, which are the Michigan Collaborative to End Mass Incarceration, the Michigan Center for Youth Justice, and the Restorative Justice Group of the Unitarian Universalist Congregation of Ann Arbor. We plan to continue this series of educational events. We don't have any people lined up right at the moment. One of the topics we're looking at is bringing an architectural nonprofit called Designing Justice, Designing Spaces, to speak on what is desirable and necessary regarding the physical layout of a restorative justice center, especially since our dispute resolution center is looking for a new space, a space that is in the community away from the jail and the courts. If any of you in the audience today have other ideas for restorative justice related topics and our speakers to recommend, you can contact us through either of our websites, the Friends of Restorative Justice.org or the Dispute Resolution Center.org. If you registered for this event, then we have your email address. We'll send you the links to the recording of this, and we will also inform you about future events in this series. So with that, I think we all have a lot to think about, and I hope everyone has a good night.